by the people of India and for the people of India. It was not an act of benevolence of the British. The Constitution was enacted because the people of India had fought for these freedoms and the basic rights. And they were extremely conscious of the fact that these freedoms and basic rights, the freedom and the liberty of the people, needed to be protected. And that is why they gave it such an important place in the Constitution, the part 3 of the Constitution of India. Constitution of India being one of the longest written documents on legal rule of law, if I may say, in the world. And I would like to quote Mr. Nani Palkiwala, one of the best legal advocates and lawyers that India has ever produced. And Nani Palkiwala, in fact, said that the Constitution represents a charter of power granted by liberty and not a charter of liberty granted by power. He was talking about the Indian Constitution. And he said that the Indian Constitution, which gave liberty, the liberty given was not a gift. It was a recognition of the freedoms and the basic rights of the people of this country, which was inherent in every person, in every Indian. So the fundamental rights are a heritage and a very precious one at that. In fact, I would say that fundamental rights are the most precious part of the Constitution of India. Now, it is a standard feature of all constitutions that they provide a mechanism for amendment. The Indian Constitution also has it in Article 368 of the Constitution of India. There are 3 methods. One is by simple majority, where the Constitution, where the Parliament, by simply passing a resolution by simple majority, can amend the Constitution. An example of it is Article 11 or Article 4 of the Constitution of India. A slightly more difficult procedure requires 2/3 majority. 2/3 majority of both houses of the Parliament, of the members present and voting. So however many members are present, we only need 2/3 of their votes. The most difficult procedure, which is part of 368, is that which is pertaining to certain more significant aspects of the Constitution, like the judiciary, the concept of federalism present in the Indian Constitution, and Article 368 itself, which requires, besides the 2/3 majority in the Parliament, it also requires ratification by half of the states in India. Now, this is very strange, because if you look at it on the face of it, to amend the fundamental rights, you only need 2/3 of the majority in the Parliament. It was not even considered important enough to include it in the part where it would require a ratification of the states. And strangely enough, if you look at the other constitutions in the world, especially the Japanese and the German Constitution, the fundamental rights have been made inviolable. They have been put out of reach of the majorities in those countries. Now, Article 13, which is also relevant here to the Indian Constitution, provides that laws cannot violate, laws passed by the Parliament cannot violate the fundamental rights. And any law violative of the fundamental right would be struck down. Now, a law includes, what is the meaning of the word law? The law includes many things which are defined under Article 13. It includes rules, orders, bylaws, ordinances, etc. But what Article 13 did not provide was that did law include a constitutional law, a constitutional amendment? So a constitutional law was never specifically included in the term law. And the question which therefore arose was that could an amendment of the Constitution, because it was not included in the term law, abrogate the fundamental rights of the citizens of this country? And this is the question which bothered the Supreme Court of India and the people of this country for decades. And this is the story that I'm going to talk about. Parliament has amended the Constitution of India 103 times till date. And in fact, the fundamental rights have been frequently amended. There have been about 19 amendments pertaining to the fundamental rights themselves. Right to property, of course, was deleted and not amended, finally. But here I would like to point out that the Parliament in India is not the only authority to have amended the fundamental rights. The judiciary has been equally instrumental in amending the fundamental rights through interpretation. Now, during the period of 1950 till 1980, it was the Parliament that was the battleground for the amendment of the fundamental rights. In the post-1980 period, the Supreme Court became the power center where the amendments were carried out through judicial interpretation, where the Supreme Court and the constitutional courts liberalized the rule of locus standi, thereby making justice accessible to the disadvantaged sections of the society. Article 21 was extensively interpreted to include so many rights. I think about 30 new rights have been made a part of Article 21 itself. Now, I'll start with the First Amendment, because the First Amendment of the Constitution in 1951 was the most vicious. It was the strongest attempt to curb and prune those fundamental rights, the fundamental rights for which our forefathers had fought for. It attacked the very soul of the Constitution of India. And strangely, this amendment came from the Constituent Assembly framers of the Indian Constitution, because in 1951, the elections had not yet taken place. So the provisional parliament which was sitting comprised of the members of the Constituent Assembly themselves. So those people, those very people who had given us these freedoms, were now attacking, were now curbing and pruning those very fundamental freedoms for their own agendas. And this was the time when, in the most magnificent document, the Constitution of India, which contained the most elaborate declaration of the human rights of the people, that those rights were vandalized. And the first battle over the amendments and over the Constitution and the freedoms was the first battle of the First Amendment, was the battle of Indian liberalism, if I may say. Now, what was this First Amendment? The First Amendment drastically curbed freedom of speech and expression. Many of you may not be aware, but Article 19.2, which imposes restrictions on Article 19, freedom of speech and expression, originally had only 3 restrictions: those pertaining to libel, slander, or defamation, contempt of court. It was in the First Amendment that more restrictions were added, which we are bearing the brunt today. Restrictions were imposed in the interest of sovereignty and integrity of India, in the interest of public order, and for incitement to an offense, which gives rise to the crime of sedition that we talk about today. It was the First Amendment which did that. Second thing which the First Amendment did was that it circumscribed the right to property and validated the abolition of the zamindari system. Thirdly, it enabled caste-based reservation by restraining freedom against discrimination. And lastly, I will say that this was the most horrific part of the First Amendment, that it fashioned a special schedule, the 9th schedule to the Constitution, in which the Parliament could put all the unconstitutional laws and they would be immune from judicial challenge. That was the First Amendment for you. And this amendment, mind you, was not made by an elected parliament. It was made by a provisional parliament. They could not even wait for the elections to take place. Within 16 months of the enactment of the Constitution of India, this amendment took place. I would like here to quote K.C. Ware, who is a famous constitutional academic, who stated about the First Amendment of the Indian Constitution. He said that the Constitution of India went from being a charter of freedom for Indians to being an impediment in the way of the will of the people of this country. It was challenged immediately before a 5-judge bench of the Supreme Court in Shankari Prasad's case. And the question was whether an amendment is included in the term law under Article 30. Because if the answer to that question was yes, it would mean that an amendment, the First Amendment, would have to be struck down because the amendments could not abrogate any fundamental right. However, unfortunately, the court dismissed that suggestion because they believed that no one could interfere with the amending power of the Parliament of India. In fact, the Indian Parliament is delicately poised, somewhere between a constituent assembly and a standard legislature, because it is bound both by the Constitution and it also has the power to change it. However, moving on, for almost 14 years, nothing happened. The law remained as was. Now, the 17th Amendment added 44 laws to the 9th Schedule. Now, all this was challenged in Sajjan Singh's case in 1964. And again, a 5-judge bench constituted was made to answer this question. The majority of the judges, the decision was given 3:2. 3 judges upheld Shankari Prasad. And 2 judges expressed their concern and reservation. Justice Hidayatullah said that in fact it was so strange that there was no proviso in Article 368 which said that fundamental rights would be excluded from the amending power of the Parliament under 368. And he said that the Constitution is a living document. It must respond to the real needs of the people of the time. And it is here that he said that words must yield to principles and concepts, because that is what holds the Constitution together. Justice Mudholkar, who was the other judge who did not agree with the majority, used the expression basic feature for the first time. And he said that there are certain things that must be kept away from majorities. And after this, the Chief Justice of India, at that time, Chief Justice Subba Rao, constituted an 11-judge bench in Golaknath. Again, a decision given by a razor-thin majority of 6:5. And what was held was that Article 13 should include constitutional amendments. That was the decision of Golaknath. Because they said that Article 368 only provides for the procedure for amendment, but it does not give the Parliament the power to amend. So they said constitutional law, constitutional amendment is a part of law under Article 13, and therefore it cannot violate any fundamental rights. The Parliament, the government reacted to this, and they passed the 24th and the 25th Amendments, which clearly stated that amendment would not be law under Article 13. The 24th Amendment said clearly that Parliament could abrogate the fundamental rights, and the constitutional amendment would not be covered under the definition of the term law. Now, this was challenged before a larger bench of 13 judges in the most famous case of Indian history, His Holiness, the Kesavananda Bharati decision, argued for 66 days, regular every single day. And one of the most important and the leading lawyers at that time, Nani Palkiwala, argued this matter for almost 32 days out of those 66 days. The question before him was that there was no court in the world which had yet struck down a constitutional amendment till date. So Nani Palkiwala was up against this huge force, and he only had one thing before him. He only had a paper written by a German professor, Dietrich Conrad of Heidelberg University. You know, Germany had suffered through the Weimar Constitution during the World War, when Hitler had excluded and abrogated all the fundamental rights. So the post-World War Germany now had a constitution which made the fundamental rights eternal and inviolable beyond the reach of every majority. So did Japan in Article 11 of its constitution. In fact, Professor Conrad gave a solution to the Indian problem. He said that he talked about something called a doctrine of implied limitations, where a certain limitation exists on the amending power of the parliament. And he said that, you know, you till date have not actually come across an extreme amendment, something like what Hitler would have done. And that is why you do not know how this power can be misused. And Nani Palkiwala cited this. And in fact, he gave examples. He said, given Article 20, the 24th Amendment, what is the effect of the 24th Amendment? He said the Parliament can delete Article 21 of the Constitution, the most important right to life and personal liberty, without which we would have no meaning. It can delete even Article 32, which is the right of redressal of every person, a fundamental right to approach the Supreme Court of India directly for violation of their fundamental rights. And more strangely, it can even delete the entire Part 3 of the Constitution itself. Now, when he spoke about the basic structure theory, he said that it comes from the preamble and Article 368 itself, because a legislature cannot rise above the Constitution which created it. So the Parliament, which was a creature of the Constitution, could not acquire so much power so as to abrogate the very essence and the very basis of this Constitution. In fact, it was very strange, he said, that Constitution, the Parliament, which does not have the power to actually pass a law which can violate the fundamental rights, has the power to delete those very fundamental rights. Isn't it strange? The Constitution is the sovereign. In fact, I would say that the Germans have a better name for a constitution. They call it the basic law. And so the Supreme Court of India, in Kesavananda Bharati case, by again a very thin majority, 7:6, upheld this basic structure theory. And they said the basic features and the basic structure of the Constitution of India could not be tampered with by anyone. In fact, Justice Khanna, who was the pivot vote, agreed, and he said that a necessary check was required to be imposed on the power of the Parliament to tinker with the fundamental rights. After this, the Parliament did try again to remove this implied limitation on the amending power of the Parliament as far as the fundamental rights were concerned through the 42nd Amendment. But that was struck down in Minerva Mills later on. I would like to point out here that yes, there is now a limitation which has been imposed on the amending power of the Parliament, especially with respect to the fundamental rights. However, the success of the basic structure doctrine has been to protect our basic rights. But if the people do not remain vigilant, if they are not aware and they cannot defend and fight for their rights, no judiciary and no constitution and no fundamental rights can do anything for them. And that is why it is said that eternal vigilance is the price that one pays for liberty. Having discussed this doctrine of basic structure, I would just like to talk about the latest amendment, which was passed last year in January, the 103rd Amendment, which enables, I know the matter is sub judice because it was challenged immediately, but I would just like to point out a few things, applying the basic structure theory here. Now, the 103rd Amendment enabled 10% reservation for economically weak of the forward castes. Up till now, prior to this amendment, reservation has been provided only for the backward classes based on caste. Now, a constitutional amendment, because of the basic structure theory, can only be struck down if it violates the basic structure. And I would just briefly like to examine if this is somewhere violating the basic structure. Now, it was thought that in Kesavananda Bharati case, the court did not say that the fundamental rights were basic structure, but it was clarified in I.R. Coelho's case that not all the fundamental rights were basic structure, but some of them were. Right to property definitely wasn't. And here I would like to point out that equality, which is what is going to be affected by the 103rd Amendment, is a part of the basic structure. It was held firstly in the Indira Gandhi election case, when Justice Chandrachud said that how can you make the president and the prime minister above the rule of law? They are as equal as any other person in India. It was held to be a basic structure in Indira Sani when the creamy layer was excluded. It was held to be a basic structure in Ashok Kumar Thakur and M. Nagaraj judgments, which talk about the concept of equality. Their whole basis is the concept of equality. And the golden triangle of Articles 14, 19, and 21, which invoke the test of arbitrariness, have also received the stamp of basic structure in M. Nagaraj and I.R. Coelho's judgments. The 103rd Amendment to the Constitution violates a part of equality in three ways. Now, it says that 15.6 carries an explanation that economic weakness will be tested on family income. Now, the criteria of family income, which is laid out, could differentiate between a person who is below the poverty line in India as well as above the poverty line. However, he does not, if he is not fulfilling the threshold of the family income as prescribed by the government, he will be entitled. So there is again a differentiation between these two categories of people. 16.6 talks about only the economically backward, economically weaker section. It does not talk about the criteria which is mentioned in 16.4, which is inadequacy of representation. In Indira Sani's judgment, very clearly it was stated that economic criteria cannot be the basis of reservation. Caste could be the sole basis, but economic criteria cannot be the sole basis of reservation. In 15.4, you talk about the backwardness being determined on the basis of social, economic, and educational backwardness. But in 15.6, the 113th Amendment is only talking about economic backwardness. So you are creating a different category of people, which is treating unequals and equals equally, which goes against the very basis of equality. I just wanted to throw some light on the 103rd Amendment, and this is where I will stop and hand over the talk now to Sebastien Lafrance, who will now speak. I have exceeded my time. Oh, I'm pretty much on time. It's exactly on time. 30 minutes are over. So Sebastien, over to you now for the law as is present in Canada.
Thank you very much. I will share my screen. I will share
yes,
the PowerPoint presentation, if I may.
Yes.
It is. Actually, I must say I cannot upload it. That's because the host, if there's a way to reactivate it just for a few seconds so I can send the PowerPoint presentation.
I will do that because a lot of people were sharing it without any logic.
Okay, thank you very much.
Right, the fact that they should know the rules of hygiene at the time of the participation on the Zoom.
Okay.
Yeah, you can do that.
Okay, thank you very much.
Out. Yeah.
Okay, excellent. So I would like to thank Professor and Dr. Bedi for her presentation. That I already see a few common points. I will address them throughout my presentation today. There's a few things that are common, but there are many differences. And let's start historically. Professor Bedi mentioned that the Constitution and the rights, and I paraphrase her, not as brilliantly as she talked about it, but there was a fight, a battle for the Constitution, and basically the Constitution in India acquired a very specific status, and we had a similar. You can see on the screen right now that there was an evolution about the constitutional law in Canada, which basically led in 1982 to the patriation. We'll see it later, but the patriation of the Constitution in Canada. It's very late. So historically, the main points that should be kept in mind is Canada became the Confederation of Canada. We had a Supreme Court that was created in 1875. The BNA Act created the country of Canada in 1867. But Canada was not fully and judicially speaking independent. So basically in 1931, with the Statute of Westminster, Canada acquired control over its foreign affairs, so a bit more power. And it's only in 1949 that the Supreme Court of Canada became the last resort court, as we call it. And okay, so somebody is writing on, anyway. So that's it. Only in 1949 that the Supreme Court of Canada became the highest court in the country. Before, all appeals in Canada, yes, they ended up at the Supreme Court of Canada. However, there was always another step. It could be brought to the Privy Council in the United Kingdom, which was the last resort. But in 1949, this is only when Canada really became, judicially speaking at least, fully in power with the Supreme Court of Canada as the last resort. And that's important to keep in mind, because we'll address it later. We'll focus our attention later on the interpretation of fundamental rights, mostly the Charter of Rights and Freedom, in the context of the amending the power or amending the Constitution. What we also need to keep in mind is the Charter of Rights and Freedom in Canada was only enacted in 1982. We had a Bill of Rights before, which was enforced. However, it was narrowly interpreted. It was not as generously, if I may say it this way, but it was not as generously and widely interpreted. The scope was more narrow than the Charter of Rights and Freedom as we know it nowadays. So in 1981, we had the patriation, as I said, of the Constitution, which means basically that we brought back the Constitution, which was in the United Kingdom, and basically Canada became its own Constitution. And in that Constitution, there was the formula, the 750, that we'll see later with the details of the amendments that are proposed. So if I may ask the host maybe to share can I share my presentation so people stop to write on it, if I may ask very respectfully? Thank you very much. Okay, so we'll see what we can do, but okay, and anyway.
The person shouldn't, the participant shouldn't scribble on the screen. That doesn't go well.
Thank you very much.
Thank you.
So what needs also to be, and we'll talk about it this morning, is what was also included in the Charter of Rights and Freedom is the Notwithstanding Clause. This is the second bullet on the page here. This is section 33, and we'll talk about it later. So that's the Patriation Act. So basically signed by the Prime Minister of the time, Jean Chrétien, the Minister of Justice of the time, sorry, Jean Chrétien, who became later Prime Minister. And then we go to the Amending formula. Professor Bedi talked about various methods, mainly 3 of them, to amend the Constitution. In Canada, there's 4 methods. And this is a table basically that sets the table for the 4 methods. But the Supreme Court very, very nicely summarized it in the reference regarding the Senate reform in 2014. So the first one is the general amending procedure to amend the Constitution. This is provided by Section 38. So this is the one that is that will be resorted to most often, or often it doesn't really, it's not as often as it was in India. We talked about 103 amendments to the Indian Constitution, and we'll see that in Canada it's really more rare. And this is why we'll bring the discussion elsewhere, still about the amending power, but we'll see that fundamental rights to be changed, or to be basically to evolve. And Professor Bedi talked about the living document that is the Constitution. We do have in Canada, we do use often an old decision from the 30s, basically to justify the fact that the Canadian Constitution and the Charter of Rights, more specifically, is a living document as well. So we use the metaphor of living tree. So we say that the Charter of Rights and Freedom is a living tree, and basically should adjust to the reality of today, and should basically, and we'll see that later in more details, but that's a common thing, a common understanding and approach to the that we have in Canada with respect to the Canadian Charter of Rights as it exists in India. So the first, and we'll go back here for a second. So the first amendment procedure, and that's a common point, a common ground with India, as well as raised by Professor Bedi. So it's not the same percentage, but in order to, using the Section 30, the most common resorted amending procedure, there must be 7 out of 10 provinces that approve it, and at least 50% of the population. So we'll talk about it later, but that's something else that is also common. So provinces are subdivided, that's how we call the subdivisions in Canada. We have 10 provinces and 3 territories. So there must be at least 7 provinces and 50% of the population that approves the amendments of the Constitution. So that's a lot. There are other, not secondary, but not as, there are more specific ways to amend the amending procedure to amend the Constitution of Canada. So the second one is the most stringent. It requires the unanimous consent of basically all provinces, and that's very demanding. And why? Because it is deemed to change the fundamental structure, and fundamental as understood by the framers of the Constitution. So core elements, when needs to be changed, that requires a unanimous consent. So basically that gives, said otherwise, it gives a veto to a province, one of the 10 provinces, to say, no, I disagree, and then the amendment fails. It doesn't succeed. So the third one, Section 43, and I put an example on the screen here. Section 43 was resorted to basically add a section to the Canadian Charter of Rights and Freedom. So Section 60.1, which basically addresses the bilingual status of New Brunswick and its institution. And that's very interesting in many respects. One of them is that there's already a bilingual, actually enough, bilingualism is official in Canada. The 2 languages are official languages of the country, but but there was not a specific provision for a specific province in Canada. And New Brunswick is a bilingual province, whereas Quebec, where I come from, for example, is a French-speaking, mostly French-speaking province where 80% of the population's language is French. So there are various interesting issues regarding this that goes beyond the topic today. So we'll limit it to section 16.1 here. But they basically section 43, because it only applied to one province, so the bilingual status of one province, that section, section 60.1, was added resorting to 43. But again, this is not the most common resorted to section, which is section 38. So the various methods, as Professor Bedi raised regarding the 3 methods of amendments in India, and also because of the 4 provinces in Canada, we also have another problem in terms of how the Constitution may be amended. The answer to it will vary only if we keep in mind section 38 and the requirement of having 7 provinces of Canada out of 10 provinces and 50% of the population. Because the density of the population, as it is discussed here in this slide, the density of the population varies from one province to another. British Columbia, that you see on the complete left end of the Canadian map here, also has Quebec and Ontario in the middle of Canada, are the most populous provinces in the country. And Alberta is the 4th. So, well, now we can see it, but so with these 4 provinces, let me just...
I would really request not to scribble. The participants, please don't scribble because it's distracting and we can't see.
Ultimately, we will be compelled to remove that person. It would look harsh, but you would have no other option.
Thank you. So the density, to go back to the issue, how just resorting to section 38, the most common resort to section to amend the Constitution, if an amendment to the Charter of Rights, also what I didn't mention and should be mentioned is the Charter of Rights and Freedom is part of the Constitution of 1982. So at the time of the patriation of the Constitution from the United Kingdom, the Charter of Right and Freedom was also included, was also enacted at the time. So fundamental rights, basic fundamental rights, freedom of expression, freedom of association, equality rights, all the basics. So to change it, let's say it would be possible to resort it, we still have a practical issue. Because basically some provinces may, by default, would be given more power regarding the criterion of having 50% of the population. So this is just a sample here, not a sample, but that's the Canadian Charter of Rights and Freedom with all the fundamental rights that I just talked about. You can have a look at it. Let's move on here. So why the Canadian Charter of Rights and Freedom is so important? It is a living document, to use the expression raised by Professor Bedi earlier. It has to be interpreted in Canada. It is a living tree. It's supposed to evolve. And the Supreme Court of Canada, being the highest court in Canada, as we said, since 1949, is the last resort court that will basically not only address and interpret the Charter of Rights, but also what they will say about the Charter of Rights will become the law as a Commonwealth country. The same thing with the Supreme Court of India, of course. So as we said summarily, the Charter of Rights and Freedom, it's basically protecting individual rights and freedoms. I really focus on individual rights. So basically any government action that would interfere with these rights could potentially breach and need to be assessed by the courts. So, but there are other ways, and that's why this is where it's a little bit different. We did address the limitation clause earlier in Professor Bedi's presentation, but because there were no so many amendments, because of the difficulty, I assume, and there are more reasons about it, but because it's so difficult to amend the constitutions, it's far from being more than 100 times that it was amended, way less. And the reason why, and there are several reasons, but one of them is the possibility for the government to basically there are other ways to not bypass, but to interpret the Constitution or to apply the Constitution, which would not need to amend the Charter of Rights or the Constitution itself to basically give way to what the government is looking for in terms of measures, in terms of action. The first limit, the limitation clause, so it's a three-step, somewhat sophisticated test that was basically discussed and created in the Oakes test by the Supreme Court of Canada in 1986. This is the first section 1 of the Canadian Charter of Rights and Freedom. So basically how rights are interpreted, usually it is with a two-step approach where the first step is to determine if there's a breach or not for regarding the one of the fundamental rights of the Canadian Charter of Rights and Freedom. So if there's a breach of the freedom of expression because of the governmental action. Something else that is required to be said here is the Canadian Charter of Rights only applies to governmental action, governmental laws, governmental acts. So it doesn't apply to private citizens. It is the case in the provinces. For example, in Quebec, the Charter of Rights, the provincial one, has a scope that is somewhat bigger, larger than the Canadian Charter of Rights, but the Canadian Charter of Rights apply to provincial laws and federal laws. So the second step in the limitation clause. So first we determine if there's a breach or not coming from the governmental action. But if there's a breach, is the court going, the Supreme Court of Canada, for example, as the last resort, will the Supreme Court of Canada say, okay, there's a breach, so we struck down, or we stop, in plain English, we stop this law to be enforced because there's a breach of the law? No, there's a second step. The second step is, okay, there's a breach of this or that fundamental right, but the second step being, can it be protected? Is it okay in the context of a free and a democratic society? So that's a very broad way to describe it. It's more sophisticated. There's a legal test to go through, but the limitation clause will potentially allow the government to say, no, there's a breach of the fundamental rights and freedom, but that breach is fine, is protected by the Constitution, and the law will not be struck down, the law will not be read down, or otherwise, mostly because it is preserved under a free and democratic society, and that's okay. And all of this, why did I go from amending power to amend the Constitution and now talking about the Charter of Rights and Freedom? It's because there are different ways, because there's not so many amendments, because of the complexity in Canada, as it is in India, but the way Canada decided to basically approach the powers provided by the fundamental tool, fundamental legal instrument that is the Constitution, is basically in a different way, rather than they're resorting to several amendments and then approaching the Constitution as a living tree directly up front. We basically do it on the side, if I may say it in plain English, in a different fashion, by having a limitation clause and also the notwithstanding clause. So whenever, that's the section 33. And we do have an example in the next slide. So I'll move on to the next slide right here. And that's very recent. And I'll comment on that after. But there's a problem with that. So the notwithstanding clause is basically the possibility for a government, provincial or federal, to say, okay, we will enact a law. It goes against a fundamental right. But rather than amending the Constitution or the Charter of Rights to basically make it comply, or ask the provinces, if it's a federal act, ask the constituents, say, okay, is it okay? Can we basically amend the Constitution to comply with the Charter of Rights and then add something to the Constitution? There's a way to say no. The notwithstanding clause will allow the government, as long as the government says it in its law and its act, to not comply with the Charter of Rights and Freedom. That's a big move. And politically speaking, it has not been resorted to very often. And why so? Because it's mostly Quebec, the French-speaking. Well, there are more French-speaking provinces, but where French is mostly spoken in Quebec, where 80% of the population speaks French, as I said earlier. Quebec was the province that resorted a few times to that section. Section 33, the Notwithstanding Clause, to avoid somehow the potential challenge in courts of a breach, of a potential breach of the Charter of Rights and Freedom. So basically, it allows the government to say, no, we know we may be challenged judicially in the courts because of what we want to do with our act, but we'll use Section 33, and upfront we'll say, no, we know we may be breaching the charter, but because of various reasons, we do believe that our act should still move forward. So there's no need to go back again about the amending power or not. So that's a way, without amending the Constitution, to still address a fundamental right, a constitutional law, a constitutional right directly upfront, and have the government and the tribunals avoiding a dialogue. So there's a theory of dialogue as well that exists in constitutional law in Canada. So the most recent example is the Bill 21, and it's known as the laicity law. So basically, it prevents or precludes people to wear religious symbols in a few professions. Teachers in schools, for example, in courts, people should not wear religious symbols, and any representative of the state should not wear religious symbols. So it is very dedicated to address a few professions, including the people who represent the state, the public servants, to not wear religious symbols, to not be challenged. And because how the Constitution, the Charter of Rights is, there's the freedom of religion. In Canada, for example, in the decision in Anselem, ANSELEM, but the freedom to religion was addressed. It was addressed several times. It is a settled right, settled freedom in Canada to exercise your religion, because Canada is a multicultural country. I'll address it later. As India, basically. So the government, to not be challenged, decided, okay, we'll go through the way to not be challenged, to not request, because what the government of Quebec could have done is ask for a change to the Charter of Rights. In the abstract, it was never discussed. But should the amendment procedure be followed, the government of Quebec could have asked the government of Canada, say, please change the Charter of Rights and Freedom, change the wording of the Charter regarding the freedom of religion, so that our act that would prohibit the display of religious symbols could be complying with the Charter of Rights. That could have been another way. But because of the difficulty of doing such a thing, also because the government of Quebec experienced as well strong reluctance about this law from most of the other provinces in the country, which criticized this act as going against the charter. This may explain very partially why the government of Quebec decided to go this way. So there's a third way, very exceptional, but very applicable, unfortunately, these days, to circumvent the need to amend the Constitution to basically make the charter evolve. It is the Emergency Act that exists, and that applies in the context of a pandemic. So what it does, and that's an extreme measure, the Prime Minister of Canada, Justin Trudeau, did not resort to that act in spite of the seriousness of the COVID-19 crisis in the world, and in Canada also. Canada is seriously affected, and many people, thousands of people died so far because of the COVID-19 crisis. But Prime Minister Trudeau very cautiously and carefully decided to not resort yet. Maybe he would, I don't know, it's not the point. But what it does, instead of changing the Constitution, and it suspends the application of fundamental rights. That's an extreme measure. It was used only once in the history of Canada, and that was in 1970 during the October crisis. So basically, a separatists movement was causing trouble, serious trouble, was basically using terrorism somehow to advance their claim for Quebec to be independent. They use violent measures and so on. So to address that issue at the time, the Prime Minister, the father of the current Prime Minister, Pierre-Elliott Trudeau, decided to resort to the War Measures Act and suspend the civil rights. So instead of going through a procedure where the Constitution would be amended, which is very difficult and complex, as we saw both in India and Canada, because of the requirements of having, for example, in one of those cases, the most often resorted to, Section 38 in Canada of the Constitution, it is very complex. So, and it takes time. But that was an urgent situation, a very urgent situation, hence the name of the Emergency Measures Act nowadays. So that act replaced the War Measures Act, but basically provides similar things, including the suspension, but the possibility of suspending civil rights. And why? Something else also that is important to mention, and I'm going, my time flies, so I'll go summarily on the next points. But there's the last table I would like to really show and discuss with you that may be very interesting. But before getting there, it must be understood that the Supreme Court of Canada does not reverse its own precedents lightly. So yes, the Constitution is a living tree, as we say in the metaphor in Canada. It is a living document, but there must be, okay, if okay, so there's so it is a living tree, a living document, but the evolution is not without borders. So the constitutional decisions, like the Supreme Court wrote in Henry in 2005, so the Constitution may be amended, I'll correct myself, but the Constitution is not immutable, it evolves. So that's a similar statement as the living tree statement, even in the absence of constitutional amendment. And that's why it's important here, given the topic. So that supports my point that the way to make the Constitution, the Charter of Rights, for example, evolve, you don't necessarily need an amendment to the Constitution. Regarding the stare decisis, again, it's just if I may respectfully ask that this person be, I don't know if it's possible.
Sebastien, can you please remove this person? He's scribbling again and again. I don't know if it's a he or she.
Clearing it, but I've not been able to trace this person. I've been clearing the drawings.
Okay, that's fine. So again, to discuss about the stability of the law and how the law is interpreted, the stare decisis, the Supreme Court of Canada is not necessarily bound by its own precedent. So the law may evolve, the law may be interpreted to make it evolve. However, there are steps, and they're identified on that slide, that it must be done because of compelling reasons. So for example, the president was wrongly decided by the Supreme Court of Canada itself, and then it should be changed. So that's a way to also aside the procedure of amending the Constitution. So that's a way to change the fundamental rights provided in the Constitution. For example, this has been said very recently in the decision in Vavilov last year in 2019. But there are more decisions about that, but that's the most recent one, 2019. And how does it apply concretely? So we have the freedom of association provided by the Charter of Rights and Freedom. So basically, the Canadian Charter of Rights and Freedom basically say that it is protected, freedom of association. But what does it mean? Does it mean only the collective bargain? Does it mean also the right to strike? So that right, amongst other rights provided by the fundamental instrument that is the Canadian Charter of Rights included in the Constitution, that right of freedom of association evolved. And if you look at the slide here in blue, you will see that earlier, back in the days in 1987, for example, or it was repeated in 2001, the freedom of association, and it's only phrased this way, that's the wording, the freedom of association is protected, that's under section 2D. So that was interpreted by the Supreme Court of Canada. No, freedom of association, it does not protect the right to strike. But in 2015, the Supreme Court of Canada says, no, to be meaningful, the collective bargaining that was acknowledged to be constitutionally protected before requires a right to strike. So that right evolved, the right to strike evolved from not being constitutionally protected at all to be recently, 5 years ago, be acknowledged, recognized as a fundamental constitutional right. It doesn't mean it was not provided by laws, regulated by somehow by regulations. It's not what I'm saying. What I'm saying here, as a fundamental right, part of the legal core rights and freedoms of Canadians, that right was not protected. And how is it possible that it'll evolve so much from one end of the spectrum to the other end of the spectrum? Well, first, we did talk about the living tree. So the fact that the law must evolve according to how the society is nowadays. So the society change. So that's one way, one reason. There are other reasons as well that can be looked at. For example, there are ways to interpret the Constitution by acknowledging the evolution, to read in, and we'll see it later, but to read in and expand the application of one fundamental right and freedom. For example, here, if you look at section 15, which provides the equality right in Canada, in the Vrian and Alberta, so basically sexual orientation was not covered by section 15, which provides the equality right in the Charter of Rights and Freedom. But the Supreme Court of Canada in that decision said by reading in that protection, extended constitutional protection in terms of equality to sexual orientation, to same-sex, basically, people. So there's one common ground here in India. Another thing that should be looked at, Professor Bedi discussed equality rights earlier. And here we have it. There is a component of Indian and Canadian society that basically is, and that's very unique. That's the fact that both our societies, in terms of different, we are diverse societies. We have many actually different ethnicities both in our countries. And Canada, there's one section, section 27 of the Charter of Rights and Freedom, that basically enshrined the protection and the constitutional protection, should I say, of multiculturalism. So this is part of the fundamental rights of Canada. But that's something I just noticed, that's a common ground here. And what I found very interesting is the last sentence of that Indian decision from 1987. So basically the unequal social profile of the population, and also the existence of minority. So it basically compared what the decision says, that it does place India in a unique position compared to several developed nations. In Canada, said differently, we do have a similar unicity as well. Not only because, mostly because of the Canadian society that is very diverse. So we'll move on to the last slide of this presentation that basically compares the core, and when we talk about the Professor Bedi discussed it a bit earlier, the basic structure doctrine in India. So there are some common grounds, very interesting, very, in my opinion, fruitful common grounds in that slide that I identified in that table that I created. So the first common ground is, yes, there is the supremacy of the Constitution. So in Canada, we phrase it differently. That's from the reference of a very famous and oft-cited and seminal decision of the Supreme Court of Canada in the reference regarding the secession of Quebec. So we do also have the Constitution is the supreme law, the supreme law of the land. The second point that is common is the existence of democracy. So it's phrased differently in India. And in Canada, there's a section in that decision that discusses it, and that in the state of Kerala, decision 1973 also. So we do consider as core parts of our society to have the democracy being respected. There's a difference. The third element of the core values of the society, in India, the secular character of the Constitution. In Canada, it's somewhat different. So basically it was, and it said in Anselm, the state is in no position to be, nor should become, the arbiter of religious dogma. So there's a fundamental right, but the Supreme Court refused to basically start, how can I say it, but start making the law, basically being too much. So there was some hesitations, not hesitation, that decision, but hesitation put to become politically active in that regard. So that's a little distinction here. The fourth one is also completely different. The separation of powers. That's been discussed, confirmed in Kerala. So the judiciary, the legislative, the executive must be separated. That's a Montesquieu principle of the separation of powers. In Canada, it doesn't work this way directly. We do have a separation of powers, but not a strict separation of powers. So there's a theory of dialogue that I mentioned earlier, and I'm referring to the fourth point here. So basically the legislature and the courts will basically enter in, between quotes, a dialogue about, for example, fundamental rights, if there are breaches, et cetera, et cetera. So there are ways to address it and back and forth between the legislation and the judicial instances, for example. And the fifth and last common ground of India and Canada, it's the federal status. The fact that both our countries are federal countries. And I mentioned the existence of 10 provinces in Canada, 3 territories. It's also very important because the provinces do have a power when it comes to amending the Constitution. As I pointed out earlier, the section 38 of the Constitution, provinces must be 7 out of 10 to change the Constitution. That's one way. It's not the only way to change the Constitution. There are other methods, but like I said, the most resorted to is section 38, unless it speaks only for a governmental measure wants to change the Constitution for one province. I gave you the example earlier of New Brunswick with the addition of section 60.1, which basically guarantees constitutionally the bilingual status of the institutions, all including the schools in New Brunswick, which is one of the 10 provinces. So that's very specific. Or also, if measures would like to change one part of the Constitution that is essential, an essential core. And this is also why we talk about it here. So that last part. So if there's a very fundamental feature of the Constitution that is deemed to be changed or amended, so then it requires the consent, the assent of everybody. So all the provinces and the federal government as well. And that's more stringent. But again, basic element to amend the Constitution, Section 38, 7 out of 10 provinces, 50% of the population, which creates a very interesting issue as well in India. That I don't, and you may think about like the number of subdivisions in India, that the very same issue may be present in some cases. So what we did today is we discussed summarily, briefly at the very beginning of this presentation, how the 4 methods of amending the Constitution of Canada, including potentially the Charter of Rights and Freedom. But we also approached briefly the other ways to do so, to not necessarily directly change it, but by way of interpreting the Constitution, that there are ways to read in, to expand, or to make evolve, talking about the living tree component of the Charter of Rights and Freedoms. So there are other ways rather than directly change and modify the Constitution. And this may explain partially, of course, why in Canada we didn't have so many changes to the Constitution and the Charter of Rights, mostly so far. We had a few, but far from 100. So what I found really interesting, and we'll finish on this note here, is both India are Commonwealth countries, both are former colonies. There are several authors who basically say that India and Canada are sisters in terms of, legally speaking, we're really close. I'm surprised that there are not thousands of academics that share knowledge together. There's a lot of things to discuss here. We do share a lot in common. However, we do approach the amending power of the Constitution sometimes in a very similar fashion. But for example, one of the methods that is used to change it, or very differently, for example, by the way the Notwithstanding Clause or the Limitation Clause, Section 1 of the Charter of Rights, that I understand to also exist in India. I'm not an expert of that part, but there are some similarities as well in that regard, I assume. So there are very common grounds and differences that should be examined further. So thank you very much for listening to my presentation today. Thanks.
Thank you, Sebastien. I think that's been a wonderful presentation. Vikas sir, I think it'll be over to you there are quite a few questions.
Yes, and we are running short of time. But one fact was there, that the part as to whether we could amend the fundamental rights or not. But one thing during this entire process, we learned that some people are also trying to amend the screens shared by Mr. Sebastien. And we had to control it within the parameters what we could do. Thank you, ma'am. I will just read the last question first. Shikha asks, whether in Canada, the idea of living tree doctrine is controlled by constitutionalism?
Well, it is basically a core principle that the Supreme Court applies oftentimes when interpreting fundamental rights of for example, the Charter of Rights and Freedom. For example, the evolution of the Section 2D, the freedom of association that I discussed, but it also applies to other rights, such as the freedom of expression. It is an interpretation principle that is commonly referred to by the Supreme Court of Canada. Oftentimes, more than 100 times, if not more, by the Supreme Court. So it's not part of the Constitution. It's not in the Constitution as well. But this is something that has a very strong value for the judges of the Supreme Court of Canada, the decision makers of the highest court in the country.
Dinesh Bhardwaj asked, the Aboriginals have been provided special rights under Section 35 of the 1982 Act, but their rights have been infringed by the Canadian government on one ground or the other. Do their rights require special protection?
So if Aboriginal people get special protection,
it is by Mr. Girish Bharati.
Well, what I can say about Section 35 very briefly, because it's a very complex section that was interpreted and examined several times. Section 35, yes, it does protect Aboriginal people in Canada. It does give them a special, it also speaks to the protection of treaty rights. For example, it is fundamental in Canada. It was a way, when the Charter of Rights was enacted, it was a way to recognize the heritage of the Aboriginal and also Inuit. We shouldn't forget about the Inuit population of the Arctic, but it's also, it was a way to recognize officially in the Charter of Rights that their special status. So are they given a special protection by Section 35? I will say yes. I will also, to connect that, what I just said, with Section 27 that I referred to earlier, which protects multiculturalism. Something that I didn't say because it was not the topic today, and I don't want to digress too much from the topic addressed today, but given the question, it needs to be addressed. For example, the linguistic minorities' rights in Canada, they are protected. However, when it comes to schools, for example, it is only protected for French and English-speaking schools by Section 23. But in light of Section 27, that also protects and gives fundamental rights to multiculturalism, there are several issues, interesting issues to be addressed. Some commentators said that these things clash, these rights clash, comes into a position. So yes, all of which to say, yes, the Aboriginal people are given a special status by way of Section 35, amongst other things. However, multiculturalism plays a big role in Canada. Diversity matters. And also, let's not forget about Section 15 and the equality rights, which also precludes discrimination based on the race, for example. So that question calls for a very long discussion that goes beyond the topic of today's presentation, unfortunately, but it's still very interesting.
Can government make law which prevails the FR?
I'm sorry, I didn't hear the question.
Can government make law which prevail FR? The question for me also is slightly ambiguous.
Can the government make a law which is?
FR, fundamental right.
Right.
Is Canadian law so flexible and living that it can be completely overturned?
Well, it's not basically, I will answer your question indirectly, but you'll see that will answer the question directly afterwards. The wording of the Charter of Rights, as Dr. and Professor Bedi mentioned earlier, the Constitution of India is the longest in the world. So in Canada, the Charter of Rights and Freedom doesn't have that luxury and very interesting feature of being detailed, which is great. So the ways the fundamental rights are interpreted, because of the wording of the Charter itself, it gives latitude to the courts to decide it if it applies or not. So can the government to answer the question directly now, can the government adopt fundamental rights? Well, that's not the job of the government in Canada. The government of Canada adopt measures, and then the courts will decide if the measures comply or not with the Constitution if a case is brought to court. But this is when the interpretation and the theory of dialogue, let's say, to answer the question even more thoroughly, let's say the measure put in place by the government breaches the Constitution. And the Supreme Court of Canada concludes, no, that measures adopted by the government goes against the Charter. We strike down, we say, no, that act is not applicable, is not enforced anymore. So we strike it down. That's one of the possible ways the courts may decide of a breach of a fundamental rights in Canada. But nothing prevents the government to enact another law in response to say, okay, we understand we breached the fundamental rights, but we will adopt another law that this time we hope will not breach the law. So, you know, back and forth, I talked about it, the dialogue between the courts and the legislation. So there's it's somehow fluid, if I may say it this way, and there's a discussion between the two institutions. So is it the job of the government to adopt fundamental rights? In this case, I would say in Canada, I would say no, it's not what they're doing. So we do have a core, which is the Constitution, and that would I would need a specific example to answer it better, but I think this is the best answer I can give at this point.
Vikram Shravan, he's an advocate, promising advocate in the High Court. Some of the states are given reservation more than 50%. What is your take?
I think it's, I'm reading the question. Some of the states have given reservation more than 50%. And is it a
violation of
Indra Sani? Okay, so Tamil Nadu, in fact, had passed a bill which provided for 69% reservation. They passed this law and they put it in the 9th schedule, and this was prior to the basic structure theory. The Indra Sani judgment. So technically now, if anything which is put in the 9th schedule after the Kesavananda Bharati case, even if it is protected because it's in the 9th schedule, but it will still have to be tested on the theory of basic structure, number one. And clearly now, after Indra Sani's, you cannot provide for reservation which is more than 50%. That will have to be justified as something which is propounded either because of some of the compelling reasons as mentioned under in M. Nagaraj. But otherwise, beyond 50% is not allowed. Otherwise, M. Nagaraj is the judgment which justifies to a certain extent on account of compelling reasons, where 50% can be exceeded, as 16(4)(a) and 4(b) also talk about.
Mr. Byansingh Bedi has been kind enough. Large number of questions he has been able to answer in the chat box itself. Thank you, Mr. Bedi. Devansh Jain asks, as it was said that the Canada deals with the Constitution as a living document on the side, so whether the Canadian Parliament themselves gives new dimensions to the existing fundamental rights in the Constitution or not?
I'm not sure the sound was cutting off. I'm sorry. Can you repeat the question?
Yeah, it has been posted at 7:23. You can also see on the screen. As it was said that the Canada deals with the Constitution as a living document on site, so whether the Canadian Parliament themselves gives new dimensions to the existing fundamental rights in the Constitution, or like in India, the courts does this exercise.
My answer will be 2 words, same as in India, the courts. That's the courts.
Thank you. The time is around 7:25. So I will, before I ask Mr. D.P. Randhawa to formally give a vote of thanks. Thank you, Dr. Shruti Bedi. It was all because of you that you brought on the platform Mr. Sebastien Lafrance. It was a wonderful experience, and you helped us to achieve the first beyond India's territory to a webinar where we could hear the other perspective. Till now, you have made us clear that the sky is not the limit. You can go even beyond that.
Thank you.
The territories are created by the state.
It's been a pleasure.
On your asking, Mr. Sebastien has come.
Yeah.
That is more important. Thank you, Mr. Sebastien. Yeah. And it was a wonderful
The audience has been so kind. The students from all over. I can see some from Kashmir University, and I have all my students here. Such a good pleasure to see all of them. So.
That's amazing. People from.
Thank you very much as well, and I really sincerely thank Professor and Dr. Bedi to have brought me into that experience. That was quite interesting and very interesting to see the common grounds between our 2 countries and the differences as well.
Before we ask Mr. Randhawa to formally propose a vote of thanks, for all the friends, the participants, because of Shruti ma'am and Sebastien, we have all participants pan-India who have joined, and even abroad. Now the question after the session, till now we were always saying the sessions are pan-India, the participants are there. Now we have participants not only from Canada but others. So those who all want to remain connected, connect us on the Facebook page, that is Beyond Law CLC, as well as Instagram, or they can connect on the WhatsApp group. We are posting the mobile number. Those who want to contact Mr. DP Randhawa. Fortuitously, when I was talking to Mr. Randhawa one day, he was sharing with me that it has been a wonderful experience that we are a batch of 1998. Mr. Randhawa has created his own niche in the politics, and politics and Mr. Randhawa are so gelled well that whenever Mr. Randhawa is there, it is understood it is politics. And when you see Dr. Shruti Bedi, you find him the epitome of on the educational side. So it's a very rare occasion where the two class fellows excelling on the both sides. That is a wonderful experience, and I thought there could not be anything better when Mr. Randhawa giving a vote of thanks to his own colleague. It's a rare occasion. It's just like a daughter and a son, a daughter and father sharing a platform and one proposing a vote of thanks. Here is a platform where the class fellow is voting a vote of thanks, and he's getting enriched from the class fellow, and vice versa. He will give us some tips how one can maintain balance during these COVID times. Mr. Randhawa has a wonderful experience when he was the president of the university. His tenure as a president of the Punjab and Haryana High Court Bar has been wonderful. He's again contesting the elections. The best person will obviously win the elections. All the best wishes for him. Over to you, Mr. Randhawa. Thank you for joining us on the stream.
Thank you very much, Vikasji, for giving me this opportunity to say thanks, to say a word of thanks. First of all, I would like to say the entire globe is fighting against this pandemic situation of the coronavirus, which has no boundaries across the globe. And same way, you have given us this platform to share the knowledge across boundaries, across globe. It's a wonderful reply, and it's a wonderful way to fight with such pandemic situation, and which keeps you live and which gives you full enthusiasm to live and to walk till end. Formally, on my own behalf and on behalf of the Punjab and Haryana High Court Bar Association at Chandigarh, I present vote of thanks to all the participants, speakers and organizers. I am grateful to Mr. Sebastien Lafrance and Dr. Shruti Bedi for this enlightening and brilliant exposition on the power of amendment of the fundamental rights and the difference thereof between Canada and India. In India, there has been a contentious topics and has seen many important court decisions and parliament legislations, including the Kesavananda Bharati judgment, in which the basic structure doctrine was laid down. And the fundamental rights are the most important part of any constitution and first topic of the study of any student of law. Being student of law, I believe the amendments or evolving of any new theory happens from time to time. Definitely not beyond the basic structures or from the access, but with the passage of time, the cultural change, the change in the civilizations does happen, which needs the new change or in the change of amendment, in the change of constitutions do happen. Such amendments must revolve around the axis and core of the constitutions of our democratic setups, which are delivering a true governance and ensure the equality and social justice. In the end, I would like to say it's a great opportunity, as Mr. Vikas Chatra has just said. I am paying vote of thanks to my own classmate, Dr. Shruti Bedi, which we share the same department, same batch, same section, same class, about a quarter century back. It was batch 95-98.
Yes.
So if I'm not wrong. So thank you very much. I also thank to all the organizers of this event as a web seminar, and special thanks to Mr. Vikas Chatra, advocate and senior member of our. Thank you very much, everybody. I pray to God stay safe, and thank you very much.
Before Mr. Randhawa, before we part, thank you, the bar. The bar has been extremely helpful to all while we are conducting the webinars. Thank you for all the support. And tomorrow again, it will be an interesting facet. because today we have Mr. D.P. Randhawa, who is the president of the bar. He is giving a vote of thanks. Tomorrow we have Mr. Dushyant Dave, who is a senior advocate. Everybody knows him. He will be delivering a keynote. He's a keynote speaker on future of arbitration. And arbitration, everybody knows, is just picking up like anything. ULS have been informed. They have their own particular section in the arbitration. So I will ask all my friends to join tomorrow at 6 o'clock. And for a change, since the COVID has started and we have 26 webinars so far, we are not conducting a webinar in the morning so that people can enjoy, hear Mr. Dushyant Dave and Mr. Sebastien. It was a great pleasure. I will ask Ma'am Shruti to share your number. I will talk separately. But again, we would love that this shouldn't be the first and the last, but we should continue to share our experiences on this wonderful platform. And again, Dr. Shruti, words are not suffice to show the indebtedness that you have brought Mr. Sebastien, and Mr. Sebastien, the way you have accepted it. And I would like to, in the end, just say a few words in Hindi, whatever you've learned. It will be a word of encouragement for all the students that you have started learning Hindi.
Excellent, excellent. Please do.
On the Facebook, I read Namaste.
Oh, namaste.
Namaste.
Yeah.
And he did use the last slide, Dhanyavad.
Dhanyavad. Yes.
Thank you.
Thank
No,
you.
but I promise, if I may say very briefly, because I know the time is up soon, but I promise the next time I will do my best to include more Hindi in the presentation. I swear, really, I can commit to that.
No, we are not asking that you should switch over to Hindi. People are loving to hear you. People love you the way you speak. But the fact that you are trying to learn Hindi shows that knowledge, for increasing the knowledge, age is never the limit. It's only the mindset. Once you have thought, there are only 3 processes of achieving anything: conceive, perceive, and achieve. And that you have shown. Thank you, ma'am. Thank you, Mr. Sebastien, and thank you all participants.
Thank you, everyone.
Thank you.
Thank you so much.
Thank you very much.
Thank you.
Stay safe, stay healthy. Thank you.